Ms. Kavanaugh?
I do have a few questions, sorry.
Okay.
On the common law immunity point, let's just zero in on that. I think the other side makes two main arguments. One, there is a long tradition of deferring to the executive with respect to assertions of statements of support for immunity or not. So that's one argument. And the other argument is that there's a long tradition, they say, where state-owned corporations engaged in commercial activity don't have that common law immunity. So if you could take those two first, I have more after that, but anyway.
Sure. So on the first two, I mean, the Tate letter, the high water mark for let's just do whatever the executive says is the Hoffman case, where there's that footnote says State Department's views are important, but we'll decide itself. But that high water mark is before the Tate letter that says the executive branch can't control the judiciary. And I do think there's some separation of powers problems plus a due process problem when you have a adjudicator that bindingly defers to one side of, it's a criminal case, it's self-dealing, and there's a due process violation. So that's just problematic. Even in the civil, it's more problematic in criminal, where someone's not liberty because you can't put a foreign government in jail, but there's massive political ramifications of being convicted. On your second question about how the immunity doctrine developed, the government is just wrong. It developed on the commercial axis, not instrumentality axis. They have two cases that dealt with instrumentalities, but the axis in the common law is one of commercial. So if the government is right about the restrictive immunity developing along the commercial, that frees them and allows them, and states too, I guess, to prosecute any sovereign itself. The Defense Department, National Park Service, they sell cokes and stuff. I mean, our sovereign governments do engage in lots of commercial activities.
Okay, next, they say for at least the past 70 years, the federal government has been applying federal criminal jurisdiction, often through subpoenas to foreign government-owned corporations. Same. What's your answer to that? So
there's been hundreds of thousands, if not a million, and they have subpoenas, and they came up with five. That's not much. And then they're over, we cite this on page 11 of our reply brief, they go all over the country saying a civil subpoena is not even enforceable against a foreign government because it's offensive to their dignity, it's offensive to international law. And so it seems a little much to be worried about their ability to get criminal subpoenas when they can either call up, we have a treaty, or I don't know. And I also think there's a huge distinction between a subpoena and actually telling a foreign country, having them convicted by a jury, that they're a criminal.
Okay, and you said earlier Congress should have a vote. The way I conceptualize this, it's like Youngstown Category 2. So Congress hasn't authorized, Congress hasn't prohibited, but Congress does have a vote. If we rule against you and Congress says, no, that we don't agree with the president's national security determinations in this area, and we're going to take this option off the table, my reading of the Constitution is Congress could do that. So Congress has a voice even if you lose.
Yeah, my reading under the Section 2 is you're going to give them the deference that they are due in foreign policy if Congress hasn't spoken. And again, you've already tied two hands behind my back saying 1331, they've spoken. Right. So yeah, then I'm having trouble in Part 2. But if I think I'm in Part 2 right, Congress has given general jurisdiction for federal courts and could not have possibly contemplated that meant sovereigns could be convicted, and that left it up to I don't know who the first Attorney General was, Randolph maybe? I don't know. But whatever that guy's name was, that they left it up to him to prosecute Britain.
The Solicitor General, again representing the administration, says nothing could embarrass the executive branch more than a judge-made principle that would vitiate a federal criminal prosecution. You want to respond to that?
Yeah, I mean, I was not impressed by that, given how ahistorical that this prosecution is. It is, countries kill people. They engage in extrajudicial killing all the time. And the notion and instrumentalities do things like lots of stuff.
Well, should it be all or nothing? I mean, that's taking a tool, telling the president then, actually, if you want to go after this bank, you can't use this tool. You have to use a more extreme tool.
The more extreme tool is a massive CFR provision that is for Iran sanction violations. It's like 80 pages that tells you how you go after sanctions violations. It has massive penalties, massive. You can, I don't want to say you can shut our bank down, but you can shut banks down for sanction violations. So what are they doing in criminal other than insulting this?
Well, I mean, I Again, I don't know, but the news reports suggest this was discussed with President Erdogan, that Turkey's foreign minister is coming to the United States this week. I mean, I don't know about all of that, but I do know that we don't know about all
Yeah,
of
but
that.
I know that you shouldn't let 12 Manhattan jurors figure this out, which is what you're doing. You're letting them go to a jury and put a foreign sovereign on trial. That's what the indictment says, is that the government of Turkey committed a crime and did it through its armed state. That's just a serious accusation. We think it's false. And I get that the executive always gets to decide what to do for criminal prosecutions. But I really think you have to assume Congress gave the executive that power from day one when it wouldn't even let foreign courts deal with diplomats, and it made it a crime to charge their servants.
Okay, that's it. Thank you for your time. Sorry to take up so much of it.